Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
The Department of Government Efficiency says it's canceled $33 billion in grants so far, and more are likely to come. Just what privileges does the government have in revoking grants, and do grantees have any recourse? Some answers from Haynes Boone procurement attorney Dan Ramish. Dan, there's been a lot of news about contract terminations, but grant terminations have been a pretty active activity of the Trump administration also. Maybe let's start with a little background on just how big granting has become in the federal government. I'm not sure the public realizes it, or even the government as a whole realizes it.
Well, Tom, there are actually substantially greater expenditures on federal grants and assistance even than government contracts.
And contracting is about a, $700 billion activity?
Yes, and federal grants, depending on the year, are generally in excess of $1 trillion. So
real money involved here. All right. So
real money.
Terminations then, and what do we know about the scope of what's going on for terminations?
So the Department of Government Efficiency has a website that has what they've referred to as a wall of receipts. And as of the middle of this month, they were reporting more than 9,500 grant terminations, totaling $33 billion in their estimation of savings through the terminations. So a very significant number and magnitude of grant terminations, and likely to increase in the coming months.
And the process for giving grants is very different from that of awarding contracts. But yet there is also that function of termination for convenience in the grant world as well as in the contract world?
So it's not exactly the same, Tom. Of course, when it comes to government contracts, federal agencies have broad rights to terminate contracts for convenience. With federal grants, when the Uniform Guidance was first issued, there wasn't a unilateral funding agency right to terminate a grant or assistance agreement. But there have been several revisions to the termination provision of the Uniform Guidance over time that have changed agencies' termination rights.
What do they look like now then?
So it potentially depends on the date of the award of the grant or assistance agreement, and also whether the assistance agreement has been amended either to add funding or otherwise to incorporate the most recent guidance. So the initial change took place in August of 2020, and this added a government right to the greatest extent authorized by law for an agency to terminate an award if it no longer effectuates the program goals or agency priorities. So that's the way they framed kind of the unilateral right to terminate, even when there hadn't been any cause or noncompliance on the part of the recipient.
And from your observation of how grants actually work, when you have a contract, by contrast, you pay as you go. I mean, you don't give the recipient the entire grant award money up front, but there are milestones and there's deliverables, or if it's a task order-based type of thing, they have to complete the task order, whatever. In grants, they don't get all of the money up front either, do they? So when you terminate, what are you really terminating? The remainder of it, or what?
So typically, when there's a termination, it's the funding that hasn't yet been obligated by the recipient. So returning funds that have been put on the award but haven't been spent yet. The way individual awards are structured differently in how they're paid out. But the termination right added in August 2020 was actually because the first Trump administration attempted to end some grants early. So there were 5-year grants, and they tried to end them after 3 years and claw back the remaining funding. And because under the original Uniform Guidance, there wasn't a unilateral funding agency right to do that, these grants, which were under the Teen Pregnancy Prevention Program, the courts rejected the efforts to terminate and reversed on the administration. So that led to adding this unilateral right. The Biden administration last year then further revised the termination provisions to limit them. So based on the updates to the Uniform Guidance last year that were published in April but went into effect for most purposes in October, the Biden administration's Office of Management and Budget required that termination provisions be spelled out in the award themselves and are also limited to the extent authorized by law. So if an individual award doesn't specify that the funding agency has the right to unilaterally terminate, if the latest termination provision of the uniform guidance applies to the award, the agency can't terminate unilaterally anymore. But that is effective as of October 1st of last year. Some agencies opted to apply the termination provision early. So, for example, the Environmental Protection Agency adopted specifically the termination provision in July, perhaps recognizing that there would soon be another change in administration that would have a different view about environmental priorities. And so the date of award is important. There's also the possibility of incorporating the updated guidance that has narrower termination rights in amendments to awards. So if a grant was modified to add funding, or if the recipient and the agency agree to incorporate the new award, the new uniform guidance, then the more limited rights may apply. Termination rights under the particular provision that applies have real consequences with all the terminations that the administration's trying to do.
We are speaking with Dan Ramish. He's a procurement attorney at Haynes Boone. So basically the government has wide discretion under the latest guidance because, as you pointed out, agencies named their own dates of when they could exercise more freedom to terminate.
So if it's between that August 2020 and October of last year or earlier, if an agency adopted it earlier, then the government has broader termination rights. If it's more recent or if there's been an amendment, then the agency incorporated the uniform guidance update to an award, then the Trump administration may have difficulty terminating those awards now. So it's really dependent on the date and dependent on the amendments. And this is playing out in court right now.
Right. And what is the court issue? That is, people have sued to keep their grants?
That's right. When a grant is terminated, there are two different avenues for relief typically. There is a contractual avenue, which would typically begin with a process that is similar to the contract disputes process, where you'd submit a claim to the grants officer and object to the termination. And there may be additional agency appeal rights from an administrative perspective that would ultimately end up at the Court of Federal Claims as a contract dispute. The other avenue is under the Administrative Procedure Act, challenging that the action in terminating the award was an abuse of discretion, arbitrary and capricious, and that's brought in district court. Those are the actions we've seen so far, partly because if there were contract actions, they'd have to go through an agency process probably before they could be brought to court.
So grantees do have rights, and it looks like they're exercising them. And getting back to that $33 billion in claimed cancellations, is there any information about who, the quality, the domains of those grants? Because the government grants money in every conceivable domain of life and science and research and activity.
Yes. So the Department of Government Efficiency, or DOGE, has a breakdown by individual agencies as to what the savings are and even down to the individual terminations. Some of the more prominent areas, of course, are predictable given that the new administration has, in some cases, photo-negative policy priorities to the last administration. So areas, of course, like international development or education or the environment. So we've seen activity in that. There are some interesting APA decisions coming out and ongoing litigation in Massachusetts over education department terminations of grants allegedly pertaining to DEI training. But the states contest that and argue that the statute contemplated providing for training in underserved communities and providing pathways for minority teachers. So there are questions about what other legal constraints apply to the terminations, and also whether they were reasonably carried out and had individual justifications for each termination, which would typically be an Administrative Procedure Act requirement.
So this issue has devolved into the chaos that everything else has, it seems, in the last couple of months. Attorney